no appearance on behalf of Mr. Nayak though. Bahini River have significantly changed the situation. The contention of the petitioner is that these activities have gradually led to severe waterlogging and frequent floods become very recurrent now. The trouble actually began in the year 2022. And since then, even a light rainfall causes flooding in the locality. Appears that considering the gravity of the situation, the respondent state set up a committee to investigate, to find out all factors of floods, which committee was also mandated to suggest and recommend short-term and long-term solutions. The writ petition further points out that the recommendations were made, but no steps have been taken by the respondent state to implement those measures suggested. And it is because of this that the area in question was worst hit by floods in the month of May and June of the year 2025. Mr. Nayak, Learned Counsel for the state. Mr. Nayak, the Learned Additional Advocate General, had on an earlier occasion submitted that he would be collating information from various departments as to the measures undertaken to remedy this flooding, and will get back to this court with a positive scheme for improving the artificial flooding in the area, in the Rukmini Gaon area of Guwahati. Has it been done?
Yes, Lordship. Pursuant to your Lordship order, Lordship, the meeting was convened, Lordship. I mean, including all.
Do you have any scheme in place?
Yes, Lordship. They have furnished me an action taken report, Lordship. I want to bring this into by filing an affidavit, Lordship.
What is the
Today.
present position? This rain, last 3 days.
Well, last 3 days also caused flooding.
Yes.
It was not all that
Not
heavy.
particular.
It was continuous, but it was not heavy.
It was not that severe
But there it is.
But there is waterlogging there.
to some extent.
Now, what do you wish to do? This is the time when you should be most conscious. Huh? Because residents of that area also are your voters.
Lordship, this action taken report has been
Today,
furnished
Mr. Nayak submits that he has received definite instructions about the steps taken,
Yes.
which he shall bring on record by way of affidavit by the next date. Re-notify on 21st of April.
One more prayer, Lordship. One similar matter is there, Lordship. Another PI 14 of 2024, that relates to flood in Guwahati, Lordship.
Inform us when the matter is taken up.
Lordship.
और उसमें तो बहुत कुछ हुआ है.
Item 13.
ये बड़ा झंझट है. Yes.
Yeah, Malad, the writ petitioner's father, Malad, he died, Malad. He was a retired district judge, Malad. And his mother, writ petitioner's mother is getting the pension, Malad. And Malad, she is seriously ill, Malad. And the mother filed an application, Malad, for nomination of her daughter. That's the writ petitioner hearing, Malad, in the pension, Malad. And writ petitioner, Malad, being a widow, Malad, having 2 minor kids, Malad. And
But you don't come in that category, no. Divorced daughter
Yes.
would not fall in that line. Of course, we have all sympathies, but how to go about it? You have spoken about some parallels in other jurisdiction,
yes,
maybe in some other departments,
yes, Malad.
and Hasiba Begum that you've
Right.
referred to.
Yes. May I point out one thing, page 38, page 38 for a moment, This is the intune communication, by which, the authorities say, may I read, with reference to the subject mentioned of, I am directed to request you to kindly re-examine the matter in the light of pension and public grievance
Is
department.
the letter by whom to whom?
From the Deputy Secretary, Judicial Department to the Deputy Registrar, Guwahati High Court,
What has High Court to do with this?
Actually, we filed a representation that was forwarded to the
Who
government.
appears for the High Court? Have you responded to this?
Basically, they wants to,
No, what they want, we understand. Have you responded to this
No.
letter by Mr. Chakravarti, Deputy Secretary to the Government of Assam?
file affidavit.
Hmm?
I'll file affidavit.
What will you file?
File,
If you have taken any decision, whether you're competent to take a decision, this has a financial connotation, whether you would be competent to pass an order or include or change. And if you wish to do so, tell us.
my lord,
Then the matter would come before this court in the administrative side and we shall consider.
let me take instruction on that.
Let the court would always let you take instructions, but this matter has been adjourned a number of times.
Yes.
Now, either we grant that concession to the divorced daughters or we don't. What is the use of keeping it pending? Hmm?
My lord.
You are Mr. Chakravarti.
Yes, madam.
We have heard Mr. R. Chakravarti, learned advocate for the petitioner, and Mr. G. Bash, standing counsel for the Guwahati High Court. Who appears for the government? Is Bora. Mr. S. Barua, learned advocate, has appeared for the state respondent. The petitioner is the widowed daughter of a judicial officer who had died in harness. The mother of the petitioner had been getting pension, but she also left the world of living sometimes in the year 2019. She died, no?
No. She's living.
The mother of the petitioner has been getting pension, but as on date, she is bedridden because of age-related ailments. The petitioner wants to be included in the list of the dependent daughter, but that was refused on account of the definition of family provided in section 143 of the Assam Service Pension Rules of 1969, which for the purposes of pension, includes wife in case of a male officer, semicolon, husband in case of a female officer, semicolon, minor sons and unmarried dependent daughters. The respondents raised objection that the petitioner could be dependent because of her being widowed, but the expression family for the purposes of pension would include only unmarried dependent daughters. The petitioner thus seeks an intervention of the court, perhaps by way of an amendment in the rules, so far as the dictionary of the Act is concerned with respect to family, but argues for reading the provision of section 143 of the 1969 rules liberally, so as to include even a widowed dependent daughter as part of the family, title her for family pension. Okay? The argument raised on behalf of the petitioner is that prior to the amendment of the rules in 2018, the category of family, only unmarried minor daughters were included. However, post the amendment, it was changed to unmarried dependent daughters. Same spirit, the learned counsel for the petitioner contends that this court also should harmoniously interpret the aforenoted provision of the rules of 1969 so as to include even widowed daughters who are dependent because not doing so would in a large measure the objections of a liberalized pension scheme meant for supporting the vulnerable family members. In many of the other rules of the other departments, a framework has been set up the family would include unmarried and widowed daughters also for gratuity nominations. In Central Civil Service Pension Rules of 2021 and the scheme for railway servants provide for including a widowed daughter having her entitlement to claim pension. यहाँ कौन सी डिक्शनरी रखते हो? ब्लैक्स डिक्शनरी है से निकालो तो नेट से ब्लैक्स डिक्शनरी ऑफ विडो.
Page 11, my lord, I have quoted.
You have quoted?
Yes, ma'am. Page 11.
What have you said?
Sir, the dictionary meaning, ma'am. The
What,
meaning
what
of
does it
aspect.
say?
Page 11.
This is unmarried. All right. क्या लिखा पढ़ो? I had read about it sometimes back. क्या लिखा? The definition of next paragraph. The definition of unmarried daughter as provided in Black's Law Dictionary is that a person that a female who has never married. However, it has been explained that it is a word of flexible meaning and it may be construed as not having a husband or wife at the time in question. That is, as for example, a widow or a widower or a divorcee. Based on this, the learned counsel for the petitioner, Mr. Chakravarti, learned counsel for the petitioner submits that the expression widowed daughter has received liberal interpretation. The situations where eligibility is claimed by them for receiving family pension family pension. The petitioner has also referred to a decision of this court in Hasiba Begum versus State of Assam and others, 2022, 1 GLT 353, wherein this court has interpreted unmarried daughters to include even divorced daughters if they were dependent. Emphasizing that eligibility depends primarily on dependency rather than marital status alone. There is no dispute here that the petitioner has been dependent for a sustenance on a mother who is receiving family pension after the death of her husband. However, the dependency of the petitioner in such situation, being an essential condition, being an essential question to be decided, would depend on various other factors. She is receiving reasonable alimony from the family of her deceased, husband, or has inherited any property in her matrimonial home, or has any movable or immovable property in her name, to qualify her to be included in the list of family who would be treated as dependent and thus entitled to family pension. No.
Depend here.
But these factors are important. So element of dependency would be necessary. Where did you show that letter? Page?
Page 34, my representation.
No, that, how many 36?
38.
Communication appears to have been made from the government to the Deputy Registrar Finance of Guwahati High Court for considering the inclusion of the petitioner for the purposes of her entitlement to receive family pension. Mr. Bash, learned counsel for the High Court submits that he shall take updated information from the registry about the current status of the determination of the issue in question and shall get back to this court by the next date. I think we would be forced to include, re-notify, make a second week, re-notify on, today is Tuesday, no? 19th of May. Just find out what can be done. We would like to interpret it liberally.
Yes.
But then it has to have the concurrence of the government.
Item 15.
This is sent to DB3. What mind apply here? Mind apply here. It appears that, just a minute, it appears that this case has been heard at length by DB3 on 12/3/2026. And 23/2026. In all fitness of things, thus this court is of the view that the matter ought to be placed before DB3 for final adjudication. The registry to put up this file before the Chief Justice in the administrative side to allocate the aforenoted bench to this case.
Your Lordship, interim passed earlier.
Any interim order, comma, shall in the meanwhile continue.
Item 16.
Wait, please, Your Lord.
Permission.
My Lord, against the order of the Central Administrative Tribunal, my Lord,
Hmm.
Lordship will find page 83, my Lord. The empty in order, my Lord.
Regularization is not possible.
Well,
Daily wage, seasonal. All that we can say is that you must get the scale. I mean, a minimum
that
wages.
was also our
Not
alternative
scale,
pair.
minimum wages. Beyond that, nothing. Yes, what do you have to say? You can understand? Understand? How do you get satisfied by asking a woman to work for last 20 years and pay her only 300 rupees per day? And when she comes up before the court or the tribunal, you threaten her of being shown the door. I mean, that's something which is a very, very unlike a model employer. She may not have any right to be regularized in service. But then can you do this? Minimum you have to pay and take instructions and tell us, otherwise we'll direct. You think that's sufficient?
It's not sufficient.
What is the minimum wages? And merely by reducing the number of hours, you have reduced it to 5 hours. But would you let her go after 5 hours? You talk of so many things. Huh? Instructions and tell us. And don't remove her in the meanwhile. We will ensure that.
Record, my Lord.
Now you want an order. You want to hide behind an order. You don't want to take a decision yourself.
Because we're council in the meantime, then they may be outside, this, they will put it.
Take it. We have heard so and so. The petitioner is a widow who has been working as a daily wage safai wala. What is the expression used here? Sweeper. We'll say sweeper. Daily wage sweeper / cleaner. In the postal department's HRO bracket mails office bracket mein hai mails RMS GH division Guwahati since January 1st 2006. For the last 20 years, she has been cleaning the office every day. Yet her job was not even made temporary or even part-time. She was initially paid only rupees 200 per day, which is far below the government's minimum wage structure. Over the years, she kept writing letters asking the department to either make her a full-time employee or at least pay her the minimum wages and give her the benefits which other regular workers get. In the year 2019, the records reveal the department gave a letter confirming that she had been working continuously since 2006. From 2023, further appears she has been getting rupees 300 per day for 7 hours of duty in the office, but was never considered for being given any regular appointment letter or any job security. Forced thus, she approached the Central Administrative Tribunal at Gauhati only in 2024. With many prayers, but one in the alternative being a direction to pay her full minimum wages. So during the pendency of the OA referred to above, her working hours were reduced from 7 hours to 5 hours, and she started getting a daily allowance of rupees 392.50 from February 2024. The usual contention of the department before the tribunal was that the petitioner was a casual daily wage worker engaged for 5 hours and therefore could not have staked her right to seek to become permanent. The petitioner, for her part, relied on Jago versus Union of India citation that she was treated most unfairly by the department, for she was not even given the minimum wages for the work which she actually did. However, the tribunal dismissed the application of the petitioner for want of sufficient proof of continuous service. Thus disentitling her claim to regularization. The petitioner apprehends that she would be thrown out of the job for her having approached the tribunal for getting the minimum wages. Mr. Mary, learned CGC, submits that he shall take instructions in the matter as to why the petitioner be not paid the minimum wages for the reason that she has been working since 2006. Previously, which fact stands admitted by the department. Let an affidavit on behalf of respondent number so-and-so be filed by the next date. First up, in the meantime, comma, it is expected that the petitioner shall not be thrown out of service. June first week. इसमें कोई law तो है नहीं अभी।
June
जागो
5-6.
ये सब नहीं कर सकते लेकिन इंसान को पेमेंट तो
हटा देगा।
मिनिमम
हटा देगा ना।
मिनिमम वेज दे दो
आप मिनिमम वेज देने के बजाय इसको हटाइएगा नहीं, अदरवाइज देन we'll have to implement जागो with full force. What macroism is this?
Item 17 to 19.
Yeah.
19 was hard, but 18 and 19 was hard by your last.
The only difference is 17, they were appointed.
No. 18 and 19 we'll hear differently. 17 we'll hear independently.
Yes,
17 you may have a case.
Because they were appointed.
So we understand that. 18 and 19 probably he.
I have brought the judgment, specific judgment.
All
Yeah,
right.
lordship, last order, compilation. judgment.
Last order in item number?
Item number 34.
3434.
34.
3434.
19 and 25 to 2026, your lordship. Concluding part of the matter. I have given the compilation.
इसमें आपको नहीं बताएंगे इसको फंसा जिसको जॉब दे दिया था उसको तो हमने डिस्टर्ब नहीं, इसको दे दिया था उसको डिस्टर्ब नहीं, जिसको नहीं दिया था उसको कैसे नहीं पता।
3434. I've given the compilation and exactly your lordship queries on the.
Where is the compilation? सबको अलग अलग करके दो. When did you give the compilation?
2475.
Long back.
2475.
24.
Yes, please argue. Please argue. Mr. Chakravarti has argued. You argue.
Lordship specific.
First, let us see our order.
Concluding part of the order. That is the fact agreement. Concluding part of the order.
Can you-
25 to 2020.
Mr. Chanda, can you give me 5 minutes to just go through all parts of the orders? इसको करना बहुत मुश्किल है। 19 का है, उसके बाद फिर फर्दर प्रोसेस, ये सीट्स वेकेंट रखा नहीं रखा। How many seats were advertised in the year 2019? Mr. Chanda, how many seats were advertised?
Yeah, my lord, 125 they have advertisement, and finally the committee, 3 members committee found 75 are available. Out of 125.
14 पेज 14 पैराग्राफ इंटरनेट पे 6 में लिखा हुआ।
रिपोर्ट में लिखाया था, वो बहुत याद नहीं आ रहा है, यहाँ देख। Now, after 2019, the recruitment, process continued, but not for these vacancies.
Not for this,
Have you made that statement?
not for this vacancy. This is the admitted position, they can also clarify.
Okay. So these posts remain vacant.
It remain vacant.
And did you appear in the succeeding, I mean, ensuing next examination?
Some of them appeared.
Some of them-
They got successful, they were appointed. Some of them,
Some of them were appointed, they would not press this.
they will not pay.
So those of you who were not successful or did not apply would be the persons who would be here.
They are,
Whether we would entertain their petition if they had appeared and failed.
no, they have not paid. They are successful. They have been, their result have been declared. Their result have been declared.
Lordship is saying those who subsequently appeared but failed will not consider their case.
Suppose the process would have begun in 2020.
So these are for the different years, my lord.
We have followed it, no?
My lord.
So those seats, they would not have kept it vacant, so many seats, 75.
So, but this posts are remain vacant, and the headquarter has given a direction to calculate, recalculate as per the vacancies. whatever
Mr. Tanda,
available.
I hope you're understanding our question. We are with you so far as the other case is concerned. Here, we are looking at it from a very different point of view.
My lord.
Not only with respect to your entitlement,
Right.
but generally looking at the service jurisprudence. When 6 years pass by and every year the examination takes place, whether 2019 advertisement could still be acted upon for whatever reason, good, bad, indifferent. That's our, would it not disturb the entire scenario?
No.
Now, where would you be placed with the promotion? Because that will relate back to the period of vacancy.
That I am satisfied. Apart from that, your lordship's query was on the last, as per your lordship.
It's all right. Every day we come up with new queries, unless we conclude
Merely,
the judgment.
merely because the important wrong vacancy position having been notified in the advertisement, which is capable of being rectified, the entire process ought not to be scrapped, leaving the applicants who have waited for all these years, high and dry, losing out their career prospects. The first judgment, I am also relying upon your lordship judgment also of this honorable court, apart from the judgment of the Supreme Court. Your lordship first judgment, I am showing.
This, we are sure you have got some judgments.
Yes, my lord. That
But
is-
then we also have
I'm just reading, my lord.
Mr. Chanda, please, we'll ask you to argue uninterrupted. But what is passing on in our mind, we must put it across to you so that you satisfy us. Now, so far as the law is concerned, the general law, the acceptable law is that if the vacancy is in excess, then that's a defect which cannot be remedied by reducing the number of vacancies. The whole thing gets vitiated. There is several decisions on this line of reasoning. You say that you're in possession of some reasoning, some judgment with other reasoning. That is one. Number two, after 2019 vacancy, when everything was standstill, in the year 2020, 21, 22, 23, every year, the respondent would start the recruitment process. How did they calculate the vacancy that time? Did they club this vacancy also with that?
No.
How do you say that? It's
No.
not possible.
No,
They could not
every
have
year,
begun.
Vacancy year, every year, there are separate vacancies were there. Every year, my lord. I can say it, my lord, confidently.
And this vacancy of
Separate, altogether separate.
this vacancy of
And,
the
yes, and there was a
Take-
state interim order not
this-
to proceed.
this 75 vacancy was left intact because of the litigation.
Fine.
Right. So in the next examination process, some of these persons who had appeared and had become successful, they also appeared and they were successful.
Right.
That's right. Any one of them in the list of respondents who appeared but was unsuccessful.
Here, my lord, all the successful candidates have.
No, Mr. Sanda, in the subsequent selection, there may be two situations. First, these people, some of the petitioners or respondents, they appeared, became successful, appointed. some who were not participated but were unsuccessful. Who are those?
For the year 2000.
21, subsequent to this selection.
This matter.
From amongst you, you are representing a group of employees. From amongst you, people who participated in 2020-21, they got their promotion, limited departmental promotion, and they don't intend to prosecute this case. All right? Some would have appeared but failed. So they are banking on this. Are there any one of them in your list?
That data is not available.
You have to
That
show
data is not available.
whether we will permit them to again come back to this.
They have subsequently.
They will-
And the reason is this, that you can't, you keep appearing, you keep failing, and then you get back to the one where the litigation has kept it alive.
Subject to your lordship, that person.
पहले list बताएं कि how many of them, it may be that they have not appeared. They are so sanguine about their being successful
Maybe,
that
maybe.
they may not have appeared.
That-
If they have not appeared, we will consider. If they have appeared and failed, we will not consider. We will record it. We have a ground.
Maybe, but that data is not readily available.
How many of the respondents here?
There are several cases, my lord. I
Sir-
appeared for one or two cases.
Who appears?
Other advocates appeared, but now here in the honorable court, I am appearing for the respondent.
Concerned with the respondents only.
And because other cases were conducted by other counsel.
How, does it make any difference so far as the case is concerned for the court? Now, other councils may have chosen to rally behind you. So far, so good. But you have to give us that number. Those who waited for the court to finally affirm that this process was correct, it was not vitiated in its entirety. If there was some problem with respect to vacancy position, that also committee was constituted. Committee suggested 75. So the only 75 seats should be filled up from among the successful candidates. We have understood you, but we want to know from you as to how many respondents can now not be considered for this because they have attempted
Next.
in the next examination and in the next examination and have failed and are depending upon the delayed litigation system.
That data is.
That data is very necessary because if most of them are, then we just
that
trash
data
it.
So available with them.
Yes.
Who wants relief from the court? Mr. Chanda, you or Mr. Chakravarti?
It's tough task for me
Hey,
to find out. Because
Why?
how many persons are there?
how many? So therefore, this is going to create confusion. No, we don't want to pass a judgment which shall lead to further, there is something called litigation policy of a state.
In this particular case.
Tell about your clients.
Two cases.
Talk about your clients. We'll make it purely, this will not be a judgment in rem. It will concern you, Mr. Chanda's clients. How many of them?
Then when I went to check it out.
Find out and tell us tomorrow. It's good. There are judgments which say either ways.
Because
I have no difficulty, but see, keeping it pending for such long, therefore we want to,
Your lordship, query of the last occasion.
that first this query is necessary today.
There, my lord, regarding the point, if there is a difference in that judgment.
You show that so that we remember it.
Yes.
Yes.
Citation number 1. That is 1989 FTC 180. First case, my lord. Case 2. Relevant case, it is the case of Union Public Service Commission versus Gaurav Dwivedi.
So,
Union Public Service Commission, Gaurav Dwivedi. Lordship, we come to page 2, para 7. Fourth line. Para 7, your lordship.
read.
Oh, fourth line, I am reading it. Fourth line, para 7.
Read entire para 7.
Rule 3 of the Civil Services Examination Rule 1998 states that the number of vacancies to be filled up on the result of the examination will be specified in the notice issued by the Commission. In the notice which was issued, it was stated, as already noted, that the number of vacancies was only approximate number which was subject to change. There is no rule, this is important matter, there is no rule which has been brought to our notice which prohibits the change in the number of vacancies which are once notified. Indeed, it is not necessary or incumbent upon the government to fill up all the vacancies which are notified, even if candidates have been selected. It is contended by the learned counsel for the respondent that even though number of vacancies could be changed, this could only have done after the candidates have been interviewed on the basis that the number of vacancies was 740. The submission is, if this is not done, the candidates will lose one chance. In the last line, para 9, I will not burden your lordship. Para 9, last two para. Para 9, last two para, page 3. Hearing of vacancies during the course of the examination do not, our mind, cause any prejudice to the candidate. For this aforesaid reason, the issuing order of the High Court dated 29th April 99 is set aside. This actually Then, revising of vacancies. This is my lord. Judgment of 2020.
Vacancy, otherwise many people would have applied seeing that number of vacancies more or less. General, your principle.
Then next judgment, your lordship will find 2022 SCC 173. Anupam Singh versus State of
UP.
UP. Brief facts which lead to filing of these appeals are done. Para 2 by 4, page 6. The Uttar Pradesh Public Service Commission issued an advertisement number 22-10-2013 inviting application for 6628 vacancies of subordinate agriculture services cadre 3. In the advertisement for the total requisition 6628 vacancies, category wise vacancies are errant. Lordship may also leave aside. In the next para, after the table, after fifth line, it was brought to the notice of the state government that there will be wrongful calculation of category-wise vacancies in the earlier requisition, and therefore the earlier requisition was required to be revised. After a detailed inquiry as to the cadre strength of technical assistant group P and the actual working strength of persons in different categories, it was found that initially the number of requisition candidates in the category of general, unreserved, and OBC was wrongly calculated. It was noticed that the diploma holders who were required to be appointed against unreserved quota, but were wrongly appointed against the diploma holders against general quota, general category. And in order to fulfill the requirement of constitutional and statutory mandate of reservation, the state government was reworked the vacancy.
Here Mr. See, the interpretation depends upon the facts of here. The number of vacancies had to be revised in different categories. The vacancies remained the same. The inter-C allocation for categories was different. And that you come to page 32. Therefore, it is dangerous to read last 4 lines or last 5 lines in a paragraph. Look at the circumstance when this proposition was laid down. Come to page 32. These are summary of conclusions by the bench.
Yes. It is not necessary, these appeals are allowed.
Now read summary number 1. The office memorandum dated so and so issued by UP Public Service Commission revising the number of vacancies is based on revised requisition by the government. The revised requisition of the government was only to rectify the wrongful calculation of the number of vacancies in different categories and to comply with the requisite percentage of quota reservation. It is not with respect to all vacancies meant to be subjected to a recruitment to a limited departmental competitive examination. No. Had it been the case, situation would have been different. I'll give you a judgment which says that vacancy position is one of the essential conditions for fixing the number of posts and taking examination thereafter. Because if there are large number of vacancies, many persons would like to apply. If there are lesser number of vacancies, many would not make so much of efforts. This is how the reasoning goes, that how the entire process is vitiated. Now look at this. Now, in that continuation, you read summary number 4.
Revising the number of vacancies in different categories to satisfy statutory requirement of reservation quota as per UP Reservation Act 1984, and that will not amount to changing
The rules of the game after the
the-
commencement of the
after
selection
commencement of
process.
the selection process.
Now, in the same background, you read the first judgment which you read out to us.
Yes, ma'am. There also it says, my lord, very specifically it is stated that mere change in the number of first judgment your lordship will find, varying of vacancies during the course of the examination does not, to our mind, last two lines, para 9 cause any prejudice to the candidates.
Now, in the first case, you read the first. What was the situation? Now, there were 470 posts and 940 candidates were required to be called. Now, in that case, either more number of candidates were called or lesser number of candidates were called. This actually was not with respect to the vacancy position. The number double the persons. Otherwise, we have so many judgments which say that if vacancy position is not correctly estimated, the entire process fails. That's what we have come to know up till now.
Because the headquarter Ministry of Communication also advised them to recalculate.
That advisory is neither here nor there. Why did they not step in? Why did they not pitch in and ask Postmaster General not to do
Therefore,
it?
my lord, tribunal interfered the matter. Therefore, the learned tribunal interfered the matter. And here it is in the judgment cited, first judgment, it is very specifically that in the absence of any rule,
In that
the absence
case,
of any rule,
in-
vacancies can be buried.
No, don't make that categorical, over generalization. That is not done. Look at this case. Union Public Service Commission versus Gaurav Dwivedi, the first case. The High Court had permitted more number of candidates to be called for interview. This was set aside, that it does not prejudice. It was not with respect to the vacancy position. आप ठीक से देखिए एक लाइन केवल पढ़ लेने से नहीं होगा उसमें. Just look at it. Look at the proposition. There is a huge difference between the facts of this case and the facts of your case. Now, in both the cases, now,
Three specific issues.
तो हम तो समझिएगा ना, ऐसा हो ही नहीं सकता ना. How many candidates should be called for interview by the Union Public Service Commission shortlisted?
In our case, my lord, the simple question was, vacancy was wrongly advertised 125. But factually, there are 75 vacancies at that. 3 members committee was constituted. And we have been declared successful, your lordship. We have been declared successful.
No, those facts are all in your favor. No difficulty. We are on a
We have
different
been
issue.
only because of, my lord, the wrongful calculation of the respondent whether applicant should serve. Whether this applicant and entire process should be, that too without approval of the ministry. That too without approval of the ministry. That too without approval of the ministry. Whether such a course is permissible. And when ministry itself advised.
Anyway, you tell us in this case, how many of your clients appeared in later recruitment process, examination process, and failed? Those who passed, they are not concerned
They
with
are
your
not.
case. They would not have even contributed to your fee. So those who have failed, they constitute a separate class. Those who have not appeared and waited for this case to be ultimately decided, that would be a different class. We'll consider. I think most of you would have tried.
No, my lord, because they are always there, my lord. I
Why
have
did you-
tremendous pressure for
Just
this
a minute,
case.
Mr. Chanda, why did you not expect this question from the bench? Especially when
No, once your
See,
lordship have said, once your lordship have said, I'll definitely.
the
I'll
one
definitely
intention,
raise-
the intention of this court while dictating the order on the last occasion was, I mean, this line was given prominence that after 2019 process, there were process continuously in 2020, 21, 22, 23, 24. Now, we accept your statement because he is not objecting to it, that those 75 positions were kept vacant, which is very, very surprising. Without any order from the court, how could they have kept it vacant without any definite order from either the tribunal or the courts? I think you must also have a recheck on that position.
There was a stay order.
Just don't nod your head on whatever the court is
There was
saying.
a stay
If the
order.
court is observing in your favor, don't sit complacent.
No.
We can change either ways.
Definitely. I will take instruction to that regard. How
You
many
take
of them-
instruction whether this position, this vacancy position was included in the further examination. In that case, We agree in principle with Mr. Chanda, but we say that we can't do anything. Operation could be successful, but the patient,
Well, my lord,
we cannot ensure the life of the patient.
well, my lord, I have also brought after 10 years.
Husband is the area, तो vacancy देंगे.
Shall remain state till the next state of it. ये तो खत्म हो गया ना. उसके बाद क्या किया? 25 के बाद, 26 के बाद, 27 के बाद, 26 के बाद.
इसलिए वो लोग vacant.
आप बताइए whether this 75 positions remain vacant. They were not clubbed with the vacancies of later years recruitment. That would be really important, number one. And you tell us how many of you appeared, failed.
He can also assert it.
I will also take
But why
instruction.
why,
To
Mr.
that
Chakravarti,
regard.
why should you not give the information?
Lordship, I will-
Why should we saddle him?
Lordship, I will take instruction to that regard.
He will have a record. though.
Take instructions and come back to us as early as possible. We don't want to keep it long. He has labored too much.
Because I'll have to, individual applicant, I'll have to make this inquiry from the individual
आपको
applicant.
बिहू के बाद रखता है immediately.
Individual inquiry,
We keep this matter immediately after bihu.
my lord, after the.
Immediately after bihu. बिहू के पहले अगर कर लें तो I am ready to give you a hearing on 8th.
My lord, there is one judgment I have also brought as per as your lordship expected. Even after 10 years, because of the process in the court cases, matters was delayed for 10 years. Then the court, Honorable Supreme Court said that it should be done immediately. Those vacancies need to be filled up.
But plus, first give the list.
My lord.
Suppose you all fail.
I
all
thought that
fail.
you'd be in possession of the list, but anyway. इसको लिखा देते हैं. Provide categorical information to this court regarding the number of respondents who had appeared in the limited competitive examination in the ensuing years and did not succeed. Mr. Chanda, learned advocate representing the respondents, seeks some time. Mr. Chakravarti, learned CGC, also is expected to verify such information and state before this court in clear terms as to whether Roman 1, the number of vacancies which was calculated at 75 in the 2019 recruitment process was or was not clubbed in the later year vacancies, and whether those positions remain vacant even today, as also the fact that some of the respondents had appeared in the succeeding recruitment examinations over a period of time, but had not been successful. नहीं, successful में तो इनके पास आएंगे ही नहीं. We are not concerned. Successful will say you have been successful, you have accepted, you have joined. Re-notify. But you have brought good judgments. It will be for our good, but we will try to know.
Even my lord, this honorable court judgment is there that.
In fact, up till now, we have not made up our mind for the delay. That delay, because of delay, we should not look at it. No. But question is, how many of you should that privilege be given to you by way of judicial order?
Even my lord, I have brought one judgment of this honorable court, or of the same postal department. This case was dismissed because assistant secretary or superintendent of post officer not entitled to file a requisition. I have brought two judgment or one judgment of this court.
Give us that information, and that would be.
Yes, that,
We assure you, we will not ask further new questions to you.
so, but that judgment I have brought on record. I have
All right.
brought on record of this honorable court. That office
Mrs. Chanda, we are not looking at it now. Whichever judgment you have brought, unless you satisfy us that you deserve to be considered, then only we will proceed ahead.
My diplo.
And there is a judgment which I can tell you, which says that if the vacancy position is wrong, the entire process is vitiated.
No, they are.
In
my
fact, in one of
statement
the
is there. I
in one
also
of the
brought that.
cases, Mr. Ken Chaudhary has argued and cited that judgment.
No, their judgment I also referred. Yeah, in this compilation. In this compilation, that supports me.
Okay.
Some of your observations supports me, my lord, strongly support. That judgment I have also placed.
All right.
8 Partha Dipankar Gogoi.
All right. All right. Let's not take names, no?
No, the case number.
The case
name.
That supports me, my lord. Those observations supports me.
वो लिख दिया कब रखें बताएं आप after due would be the entire month. You tell us which date. ठीक है इसका the number the this what is that the 2143 we are inclined
4-3.
2143
Item 17.
item 17 we are inclined to go by you.
I can 17, my lord, on a different basis.
So therefore we are positive in that.
In your favor, court is in.
We are in your favor in 2143.
All right, my lord, I will bring all this.
All right.
Submit. And in my own submission, my lord, your lordship will come to rescue me in these cases also. Because those judgments, and I will bring more judgment.
Date तो बता नहीं रहे हैं आप.
Judgment also support.
Date.
Date, my lord, April, any day, past week.
30th April 30.
नहीं 20 तो 20 तो है नहीं. Keep it on 28th of April.
Yes.
21st.
28th of April.
2/8.
2/8.
Let it, little early.
Early, then it comes on 21st.
21st already. Lots of.
Huh?
20%.
21st, there are many matters which have been fixed, so नहीं हो पाएगा. Keep it 28, doesn't matter. You have waited for so long, unless you have some difficulty. 28th. 1 or 2 days accommodation we will always give. Suppose you are stuck up somewhere, we will keep it for the next day. No, 29th, 3rd. But prepare for 28th.
Item 23.
Yes.
रेगुलरली रीसेल रहेगा तो समझ क्या करें 3 पत्र
Yes.
My lord, in this appeal, my lord, the petitioner union assailed judgment and order dated 30th of April 2025 passed by the Honorable Single Judge, my lord, passed in WPC number 6090/2022, my lord. The judgment I have annexed at page 56, my lord. 56 onwards.
resolution would still close the rules.
My lord, I like to draw attention to paragraph 9 at page 61.
इतना लंबा लिखता है कितना पेज का लिखा है ज्यादा नहीं है
8
चलो just a minute.
Yeah. One is cancellation of registration and under is final closure notification. Yeah, it's at page 106. From premises of ministry.
From the front
Page
page?
106. Yeah. It is a cooperative society.
Firm क्या है cancellation? हाँ.
Cancellation.
No, cancel होगा उस समय बाद में. What?
Industrial unit is closed by the next page. Because with immediate effect.
HRA भी मांगता है.
Hmm.
VRS. Where is the VRS scheme?
Scheme.
Yes, scheme is,
Did you place that scheme before the court?
my lord, I have not placed, but respondent has placed, my lord.
They have placed.
Yes, my lord.
But the court says that VRS scheme was not brought on record.
My lord, it is at page 178. One 78.
Hearing में है कि इसको hearing में डालना है.
Hmm?
Hearing में डालना है.
Hmm.
No. This scheme was, this is the general Department of
General.
Public Enterprise scheme
Yes, my lord.
for your spinning mill.
No, my lord, for all PSU. Of Assam.
No.
Cabinet decision is.
No. We are not concerned with this. Where is the cutoff line date?
My lord, that is close to
Which paragraph?
paragraph 2. Bottom of the page, my lord. In all calculation of VRS benefits, the basic pay and rate DNS allowances shall be taken as on the date of application by an employee opting for VRS and
Cash
the
payment,
date of
balance
closure.
of contributory provident fund, gratuity, unpaid salary. It doesn't take care of HRA.
Yes, my lord.
Hmm?
My lord.
Like my 1 second. Savings. In all calculations of VRS benefits, the basic pay and rate of dearness allowance shall be taken as on date of application by an employee opting for VRS and the date of closure of the SLP, whichever is applicable. No request for any revision shall be entertained thereafter. Now, where this is the basic scheme of VRS.
Yes, your lordship.
Now, there were these fill in the blanks which we need. Where was the VRS scheme for your company, for your the workers of your union? Where is that? This we are not concerned. This only says that the date, relevant date would be fixed, either closure of the mill or opting out for it.
Yes, your lordship.
So therefore, this is dependent on the scheme which is made applicable to you.
Yes, my lord.
So where is that scheme which was made applicable to
My
you?
lord, for my mill, no any separate scheme is there, my lord.
ये problem क्या है sir? आप इसको
This general
enough
scheme is
because-
applicable. My lord.
Therefore, it will be from the date of closure.
My lord, here it's mentioned that date of closure. My members of the appellant union,
Recommend as per those notifications. ये तीनों के लिए असम शहीद पुष्प
यहाँ तो acceptance का है ना, they accepted it. Nobody say that that date is not important. They accepted it in 2010.
इसमें भी लिखा है सर ये देखिए in terms of this page 104
This scheme does not say whichever is later. It says date of application by an employee opting for VRS. So VRS was introduced. It was not in existence. It was introduced. So you must have accepted it. Therefore, matter proceeded. Or the date of closure. See, for all practical purposes, it had been closed long time back. It was only because of otherwise, even the Orissa firm could not control it, could not revive it. And then nothing happened. So this, for all practical purposes, was closed. Now, only because there was a final closure in 2011 that you want it to be calculated, at least get this.
yes, your lordship.
Please get this and don't drag this into litigation. Otherwise, you'll not even get that.
Definitely, your lordship. My lord.
Have you got everything in accordance with this VRS? Nothing.
No, my lord. My grievance before.
But we are asking you something else. Have you got your VRS benefits
I have no.
from 2010?
Till 2010, June 2010.
Till क्या होता है? Voluntary retirement scheme, whatever is the scheme, you get it. From 2010, you've got it. There is nothing pending.
Till 2010, I have received, my lord.
Till क्या होता है?
But
बिल इसलिए होता है कि उसके दिन में काट ऑफ 2010 जो मिलना
problem is that, my lord.
So from
I
2000,
got your point, my lord. Problem is that, my lord, actually this benefit has been given in terms of unpaid salaries and other benefits. That's why I'm saying so.
be satisfied. We don't have anything here.
My lord, my
How do
grievance-
we say that it is dependent on the closure? Because this is open-ended, this notification of 2006.
that closure, my lord, on 30.
Yeah, what is your stand? Whom do you represent? कोई system ही नहीं है.
ये देखिए 107 the government says please to be recommended by the cabinet subcommittee revision of space of SLPs following defunct as making loans for so and so this team and the ever says line defunct so and so department this notification so put her there. The government decided to close down the mill societies and employees liability shall be borne by the administration of the state. The insurance in persons of so they will go by that 2000 which is general किसी के लिए कोई specific नहीं है इससे इंडिपेंडेंट पैसा देगा सो वो लोग 2010 हिसाब करके दिया एक्सेल क्लोज अगर 11 so they want that it should be counted जो बेनिफिट है 11 का वही केस पैराग्राफ 5 में वो लिखा कर सकता है इतना झंडा कर दिया है बस 1 साल का बहुत हो जाएगा डिसाइड करेंगे अभी मैं थोड़ा दिस इज द इशू फ्रॉम पैराग्राफ 5 वही है क्लेम पैराग्राफ 5 ऑफ द जजमेंट करेगा वो तो है नहीं These documents have shown up on that date, thereby notification that was. Something different. ठीक है जो भी है this is their case.
And they, see, this is 9 months or 10 months,
Yes,
salary. But so far as medical bills are concerned and HRA, that component is not to be added in BRS.
my lord, that part,
That scheme is not there.
my lord, that is the,
Which scheme did you introduce, Mr. Department for Corporation? Which scheme did you introduce? The one which is here as part of record of 2006.
Yes, Your Lordship.
No, can't be.
Then it is a general
So
notification.
with respect to them, what did you say?
With respect to them, Your Lordship, otherwise the mill is a cooperative society. So the registration got cancelled in 30/10/2010.
Why do you have to answer all that? That question we have not asked you, no? Have we asked you that question? Now, if you raise that ground, then we say that give it from the date of closure till the date of closure. We are asking for something else. Now, there must be some scheme which you would have introduced. No, this is the general format of 2006. Which scheme did you give them?
Registration
Where is the where is that communication which says anyway this matter will be heard? Okay, this SLCom. This writ appeal is directed against the judgment dated 30/4/2025 passed in WPC number 6390 of 2022 by a learned single judge in this court. Stop. The appellant herein is the Assam Cooperative Spinning Mills Employees Union, which was registered in 1992 and which represents ex-workers of the now closed / defunct Assam Cooperative Spinning Mills Limited, Boitamari, Bongaigaon. Next, it appears that the mill was set up in 1979 as a state-supported cooperative cotton spinning unit. However, it stopped production in the year 1994 due to lack of raw materials, working capital, and mismanagement, leaving the workers unpaid since August 1994. There were many, next paragraph, there were many revival attempts, including a 49-year lease to a private Odisha firm in the year 2000, but the mill could not be revived. Since 2004, the union had been demanding voluntary retirement scheme benefits under the revised VRS policy, इस पेज पर था
178.
1 7 क्या लिखा है? हम्म, हम्म, हम्म। VRS policy for the employees of the state level public enterprises of Assam. Which was notified on 15/2/2006. The records reveal that the registration of the mill was cancelled on 30/10/2010. Thereafter, a liquidator was appointed. The industrial unit was officially closed on 29/7/2011. 29/7, officially closed on 29/7/2011. It was notified by the Corporation Department and confirmed by the Public Enterprise Department. The a writ petition came to be filed by the appellant union by WPC number 5203 of 2011, wherein a bench of this court, by order dated 18/11/2014, gave a direction to the respondents to finalize the VRS by 31/3/2015. Despite that direction, when the scheme was not introduced or acted upon with respect to the workers affiliated with the appellant union, a contempt case was filed. During the pendency of that contempt petition, a chartered accountant was appointed by the state who calculated the VRS only up to 30/10/2010, which was the date of the cancellation of the certificate of the mill, and did not include house rent allowance and medical allowance. In any view of the matter, the contempt case was closed, giving the liberty to the appellant union to challenge such calculation afresh. Pursuant to this liberty, the appellant union preferred the writ petition number 6390 of 2022, stating that the VRS must be calculated up to 29/7/2011, which is the actual closure date officially. That HRA and medical house rent allowance bracket HRA and medical allowance bracket MA salary components could not have been excluded. Could not have been excluded. It appears that the learned single judge, by the impugned order, by the impugned judgment, rejected both the prayers, holding that no VRS, no specific VRS scheme / proposal was placed on record in order to satisfy the court that the VRS was payable to the workers of the appellant union from the date of cancellation of registration of the mill or from the date of official date of closure of the mill. That apart, the learned single judge also held that in the absence of any challenge to the cancellation of the registration of the mill dated 30/10/2010, all works must have stopped. And therefore, it could not be claimed by the appellants, could not be claimed by the workers for calculation of their VRS from the date of official closure. Because for all practical purposes, VRS scheme contains clauses which are accepted, which have to be acceptable to the parties. In that context, it was observed by the learned single judge that in the absence of any attempt of the union / laborers / workers of challenging the cancellation of the registration of the mill, no fault could be found with the chartered accountant employed by the government to calculate the VRS till the date of cancellation of the registration of the mill and not from the date of official closure, which was only on paper. The VRS scheme, which was notified on 15th of February 2006, for the employees of state level public enterprise of Assam, clearly provide that the package under VRS in all the SLPEs in the state, irrespective of whether the SLPEs are to be closed or revived. SLP का मतलब होता है state level public enterprise, है ना? तो हम SLP बोल दे रहे हैं, but आप लिखिएगा state level public enterprise, correct?
Yes.
What did I say? In all the SLPs in the state of Assam, irrespective of whether the SLPs are to be closed or revived, or whether the SLPs can afford to discharge the dues to the employees on account of VRS from their own resources, from their own resource generation, but excluding Assam State Electricity Board, will include ex gratia of 15 days pay, bracket basic pay plus dearness allowance, bracket close, only against each completed year of service rendered or for the months of service left, whichever is less. 2, cash payment for unutilized leave for a maximum period of 240 days, bracket basic pay plus dearness allowance only. 3, balance of contributory provident fund dues payable as per the regulation of CPF. 4, gratuity as per Gratuity Act. 5, unpaid salary / wages, bracket basic pay plus dearness allowance, bracket close, up to the date of acceptance of VRS by the employee. मुश्किल है. Savings of group insurance scheme. Next paragraph. In all calculations of VRS benefits, according to the 2006 revised policy, the basic pay and rate of dearness allowance would be taken as on the date of application by an employee opting for VRS and the date of closure of the SLP, whichever is applicable. Either. नहीं तो आपने जब अप्लाई कर दिया, आपने जब क्लोजर हो गया तभी तो अप्लाई कर. No request for, it was also specified in the policy of 2006 that no request for any revision would be entertainable thereafter. One of the conditions, some number 7. One of the conditions is stipulated in the 2006 revised policy is that full implementation of VRS will precede the filing of closure application in respect of such SLPs. SLPs.
अपॉइंट कर दिया तो लिक्विडेशन होने के बाद ही क्लोजर. So moment liquidator appoint then another Prohibitions Act. So registration cancel, then liquidator, then after closure, then only closure. So because liquidation में दूसरा भी था किधर तो then so therefore cancellation से दिन से ही होगा इसलिए
cancellation
दिन से होगा क्योंकि otherwise this process is closure is for the purpose of liquidating क्योंकि सेट को सेल करना है दूसरा लाइबिलिटी देना है. Cancellation is the first stage, then liquidation, then notification. And so relating to employee, otherwise property would have been sold from there, they would have been given, but here government has given.
The learned counsel for the appellant union, while assailing the judgment of the learned single judge, who did not find any enforceable legal right of the workers to be proven, submitted that the VRS policy of 2006 states that the benefits have to be given up to the date of closure of SLP, which in this case is 29/7/2011. The HRA/MA are salary components as per the settled law. The contention therefore is that the registration cancellation date was wrongly used as the watershed date for calculating the VRS benefits. Stop. In other words, for the workers having remained unpaid for more than 30 years, comma, they got only partial VRS. And because of such cut-off date of registration of the mill having been applied, comma, the workers were devoid of the benefits of 9 months of salary, HRA and MA.
Let me submit one thing, Miller. The HRAM is for entire period, Miller, not only this 9 months. Miller.
And the usko 9 months se nahi qualify kiya. HRA MA is not there in this scheme.
Miller, actually it's covered by judgment, Miller.
Anyway, therefore we are admitting this. We will admit this. So the issue, therefore, before this court is as to the correct cutoff date for VRS calculation. The 2006 SLPE VRS policy. क्या लिखा है? The issue therefore is the issue. Huh? Okay, what did I say? Start the line. Stop. Would it be the date of registration cancellation or the date of industrial unit closure? Stop. The other issue is that in the case of the appellant union and the affiliated workers, no specific date of acceptance, and in that case whether the date of final closure should have been the determinative date. An ancillary ground raised by its adjudication is whether HRA and MA are to be included as salary component in VRS calculation for closed SLPs. Closed SLPs. The question therefore would be that whether the respondents can unilaterally provide a date for calculation without even specifying as to what would be the relevant date. A cutoff, a downward cutoff date according to the appellants, is not only arbitrary, which is promissory estoppel, and also violates natural justice. The matter is required to be heard. List for hearing, you bring it on record, the communication by which it was made effective. Then we'll see what date were you and what communication did you make to the chartered accountant. Related it. That way we will understand that this was the VR scheme that they accepted. Issue is very simple, but because the single judge did not have the advantage, and here also in appeal we don't have the advantage, we don't want to send you back. Make payments under the VRS at least till 2011, whether they would get more for 9 months and HRA and MA for all this while, we will consider. Correct? List for hearing in June कर देते हैं, July. June में नहीं, July कर देते हैं.
चले जाने के बाद
June में करें, July में करें. Where is the date in July? List
जुलाई में postpone करता हूँ तो मुझे कुछ दूसरा हो जाएगा. Like same.
June में नहीं, July में करें. On 13, 14, on 17th of July.
Friday.
ऊपर में लिख देना, we have heard Mr. M. Saikia, learned advocate for the appellant / union, and Mr. G. Bordoloi, standing counsel for the Department of Cooperation, and Mr. S. Barua for the state.
Supplementary list, item 28.
5 मिनट में नहीं आएंगे, 5 मिनट में नहीं आएंगे, बहुत लंबा चौड़ा हो गया. Anyway.
Museum magazine का notice करिए.
Mr. Chaudhary will take 5 minutes leave.
Yes, yes,
We'll just come back.
yes.
We must remove this labor union. Now let us come to judicial officers. We'll take 5 minutes.
No, no, it's okay, madam. Wrong calculation.
Yes.
Item 29.
But this writ appeal is against an order dated 26/03/2026, whereby the stay vacation application filed by the appellant was dismissed, my lord. And by way of the order, my lord, an infrastructure project was stayed, my lord. I'll very briefly narrate the facts, my lord, short of all the unnecessary details, my lord. So then, pursuant to an NIT, a work order was issued to the appellant on 24/1/2019.
Yes.
Pursuant to the work order, the petitioner mobilized men and material and started the work, my lords. However, my lords, the incumbent executive engineer at that point of time, one gentleman called Mr. Chamed Ali, started causing hindrance in the process and disturbing the appellant to finish the work, my lords. When situated such, my lords, all of a sudden, my lords, without any notice, the work order was terminated by the same executive engineer, my lords, Mr.
We are not
Chamed Ali,
concerned.
whatever,
We are not concerned with the
we're not
name.
concerned now.
When was it terminated?
Terminated on 9/12/2020.
9?
9/12/2020.
Hmm.
Thereafter, my lords, what had happened, the same incumbent engineer had issued a purported NIT, which was never published in the newspaper or published in the online portal. Now, on the basis of that NIT, my lords, the present respondent number 6, my lords, was allotted the work. My lord, to note, my lord, the work was allotted, the notice to proceed with work was allotted on 20/02/2021. And on 21, that is the next day, my lords, a bill of rupees 1.91 CR was raised by the respondent number 6. Thereafter, my lords, being aggrieved by the termination,
we approached the Honorable High Court, my lords, by filing a writ petition with two folds, my lords, prayer, two folds, my lords. The first prayer, that the termination was not correct, and second, the allotment of work to the respondent number 6 was not proper, my lords. Now, after filing the writ petition, my lords, the Honorable Single Judge, while deciding the matter, Honorable Single Judge had held, my lords, that he would not interfere
With the termination.
order of termination. But he did not go into the legality and validity. He just said, my lord, the Honorable Judge just said, my lords, that natural justice was complied with. He was given adequate notice, and that the executive engineer had the jurisdiction.
That's right.
And in the second part, my lords, with regard to the allotment of work to the respondent number 6, the Honorable Judge observed that there were gross anomalies, my lords, in allotting the work to the respondent number 6. My lord, may I produce one paragraph?
No, no, but-
Well, I'll narrate the facts, my lords. So, my lords, the Honorable Single Judge had directed that with regard to the second prayer, the allotment of work, there should be an inquiry which should be conducted, my lords. Now, pursuant to that writ petition, my lords, and writ appeal was filed. My lords had handled that matter when it came up before my lords. Now, in the intervening period, what had happened, my lords? An inquiry, my lords, was initiated by the chief, by the department appointing the chief engineer as the inquiry officer, my lords. Pursuant thereto, my lords, the inquiry report was furnished, and upon furnishing of the inquiry report, my lords, it appeared, my lords, that there were gross anomalies, my lords. The notices which were served was never served. The notices were forged. The NIT by which the respondent number 6 was allotted the work was never
What happened then?
was never
That
published.
report-
My lords. Thereafter, what had happened, my lords? The department had issued certain communications, my lords. One communication dated 5/6/2025. 17/6. I won't trouble, my lord. There are 4 communications issued. In sum and substance, my lord, by the first communication, the department had directed that you take action against the respondent number 6. You recover the money which has been paid to him, and you take action against that erring Chamed Ali, my lord, executive engineer, there was vigilance cases, my lord, and he was penalized and pension was stopped, my lord. And thereafter, in the same communication, my lord, the department had directed that my termination was based on fraud and forgery, and it was not in terms of the contract agreement. So the department had decided to restore me to the position where
you were asked to
terminate the work.
Then-
Thereafter, my lords, these 4 orders, my lords, these 4 orders came to be challenged by the respondent number 6. Now, all the while, my lords, the contention of the respondent number 6 was that they had already completed the work. That's a pleaded fact, my lord. I can show it from the records. Now, they challenged these 4 orders, but the Honorable Judge refused to interfere with the allotment of work, or rather, reallotment of work in my favor. But the Honorable Judge has said that you do not take any coercive action against the respondent number 6 during the pendency.
must be an interim order.
Yes, interim order. Thereafter, my lords, again, because there was dearth of time, my lords, the infrastructure project was required to be completed by 31/3. Thereafter, another 2 communications were issued by the respondent department that you immediately direct the appellant to resume the work as soon as possible and complete it, my lords. Now, those 2 orders were also challenged by the respondent number 6. Although he's not prejudiced, he said he completed his work. So that came to be challenged, and by way of another writ petition, which is the connected writ petition here, my lords. And in that writ petition, my lords, while the Honorable Judge took it up for issuing notice, my lords,
You're a party in that writ petition.
I was a party. The court had observed, my lords, bereft of anything else, my lords, the court only observed that I could not have been allotted the work because of the first writ petition which I filed, my lords. The first writ petition which I filed, and where the court had refused to interfere with my order of termination. So according to the Honorable Judge, it was an imprimatur on the judgment passed by the earlier coordinate bench. Now, my lords, what had happened at writ appeal? After,
It was not an imprimatur. In fact, it was just the opposite of it.
yes, exactly, because the inquiry was conducted
That's all right. So what do you want now?
Now, my lord, what, just.
The view of this court is
Yes.
that you should not have been given that work to be resumed. This is the view of this court. What do you have to say to this?
No,
And there are reasons for it.
yes, yes. Now what had happened, my lord?
The question is that if respondent number 6 also was not doing his work,
Yes,
he had submitted bills without even mobilizing his resources.
yes.
That was found to be wrong. An inquiry was conducted. Inquiry,
Yes,
it was
yes,
found
yes.
that the allegation is correct.
Right,
Then agreement with him had to be cancelled
yes.
and a third party should have been given.
My lords, because the answer to that would be, my lords, that was what was argued before the honorable single judge, my lords, that it's a case where fraud.
And why this urgency of 31st?
Because, my lords, in terms of the communication,
It shall be extended.
it shall be
It
extended.
shall be extended or not extended. That's for the government. They will not leave
Yes.
the work
Now,
undone.
The writ appeal which was filed, which was handled by
We are not interfering.
which came up before my lords, my lord may kindly turn to 196 for a moment, page 196, my lord. Just for a moment, my lord, kindly.
I will issue notice to respond number 6 and the state will be required to
my
respond.
learned-
No interim
My
order.
learned friend was gracious enough to serve advance copies on respond number 6.
Not gracious enough.
Yes, without a notice.
That
my
was a
lord.
duty of him.
No, no.
Otherwise, we would not have heard you today.
Kindly come to page 1.
Is it a matter of grace that I'm hearing you?
No.
I am under an obligation to hear you. Huh?
But I'm always obliged.
When you file a petition and you challenge some orders which are in favor of respondent number 6,
Yes.
would you not serve them?
Yes.
That's a matter of compulsion,
Yes,
not
yes.
grace. Yes.
My
So
lord,
we are not doing anything.
Page 199 for a moment, kindly. Kindly, my lord.
Hmm. But in any case, whether respondent number 6 is given or not given, we'll ask the state now. You are nobody. You should not be given.
My lord, page
Not at all.
Page 199 for a moment, kindly.
Let the single judge decide it.
This is the order passed by my lords, my lord.
Abhi mein?
Yes. Nonetheless, when the matter went before the third paragraph, my lord, nonetheless, when the matter went before the court, the learned single judge found no folly with the decision of the respondents in cancelling the contract of the appellant. However, on account of various startling facts having been brought to the notice of the court by the appellant regarding the selection of a new concessionaire without indicating the portion of work which was to be completed by him and release a huge amount of money towards the bills raised by such person without the work having been started by him, an inquiry was directed by the learned single judge. Pursuant to the inquiry, the allegations leveled by the appellant was found to be correct. The respondents in their wisdom recalled the cancellation order and directed the executive engineer to entrust the balance work to the appellant by communication dated so and so, the executive engineer by communication dated 19/8.
So you withdrew it.
Yes. So I was asked to complete the work. We came and we placed it.
Let it be decided. Now because of you and respondent number 6, the entire work has been delayed.
No, I already.
The government has just behaved like a mute spectator. Only when matters came before the court or somebody noticed it, they rose from their slumber. That's for them.
I cannot be blamed for that, my lord.
You cannot be blamed, so it will be decided. There is no urgency to interfere with the refusal of this single judge in passing any interim order.
In that case,
Don't worry about the lapsing of the project or fund. It shall be revalidated.
Yes.
You don't be concerned about the government's financial, decision making. Don't be bothered. It's your requirement. We are not interfering with this. All that we can do. No.
If an observation with regard to the funds, the extension.
Nothing, Mr. Counsel. Mr. Mohanta, you please withdraw this. In order to, we would request the London single judge to decide the issue as fast as he can, as fast as it could be. Only if you withdraw, otherwise we'll say that it is bad.
Yes.
Your respondent number 6 has not come here, we don't know. But with respect to you, you could not have been allotted that. We have not passed any order in that writ petition, which though it was it was allowed to be withdrawn, because if seen independently by us, by this bench, we would not have entertained that petition in the first instance. Because it was entertained, we allowed it to pass off and permitted you to withdraw. That's a decision. If A is bad, in his place B is given, B also doesn't work. Is it necessary that work should again be given to A?
Because the reason is just one moment, my lord.
Take a call. We have other matters. We have to rise at 3.
Yes, just one suggestion. Just one.
Yes.
It's an infrastructure project, my lord. Now they have.
You worry about infrastructure project. You are the one who forestalled it, who delayed it, who spoilt it.
No, my lord. Fraud was played upon me.
The
was
contract
terminated.
period, the contract work had to be completed by which time? Original contract.
That because.
And you took how many years to at
COVID
least?
period, my lord, 2019, my lord, remember.
Nothing.
My lord, just one.
Lost your right.
Just-
Now, you have two options because we are in a hurry.
Yeah, yeah.
We are not in a hurry not to understand the matter, but we are in a hurry. We can't give you further longer arguments.
Yeah.
Time. Now, either we don't hear it today, we hear it on some other day and then dismiss it by even a stronger reason. Or you withdraw this to pursue your rights before the learned single judge.
Just one line, my lord. My lord, since it's a project, my lord, and they have their contention is they have already completed the work. I may be allowed to, during the pendency of the case, I may be allowed to complete the work, my lord. Rest can be decided later, my lord.
And then you raise bill of 5 crores.
I never raised the bill. He raised the bill after a day. my lord.
Mr. Mahanta, take a call. We have given you two options. And
I leave it.
And don't say this is a Hobbes's choice. This is not a Hobbes's choice. I have given you two options. Not the only option of withdrawing it. The other option is that we adjourn it for some another date when we ask Mr. Nayak to explain. And in that case, Mr. Nayak also may face some uncomfortable questions.
That's a better option, my lord. That's a better option.
If I'm not going to opposite direction, pass by the.
Correct. But we will be asking of our own. No, Mr. Nayak, we will be asking of our own. Why do you take this stand of seesaw? Give work to him, withdraw, give to another person. You complaints are raised, then you give back to him. Is this done? It's not done. All legalese apart. What do you want? Withdraw, go before the thing.
Another day, my lord, what you put here.
As pressure, unnecessarily you consumed half an hour. Others who are sitting for their matters.
There's some pressure from the client. The last day was today.
Why not we decide it today?
Last day was today.
How does it make a difference? Last day for what?
Well, for completion of the work, the funds would lapse.
You have crossed that deadline so many number of times.
You are interested in release of money by
No, I have to complete the work. my lord.
Nothing more.
Nothing. इसको dismiss करने की बात कर लेते हैं because Mr. Mahanta no, Mr. Mahanta you have his argument dismiss करने लिखा देना. No, we are not inclined.
Then I leave it to Mohammed.
Better option is to recall to withdraw this and go before. Otherwise, we'll give our own reasons that will spoil. That will be the end of road for you in that.
Right. Some directions will learn.
No direction. We will say that Mr. Mohanta will seeks permission after some argument to withdraw this application, withdraw this appeal in order to pursue his claim before the learned single judge where the matter is pending.
Expeditious disposal.
With a request to the learned single judge to decide the matter.
Expeditious.
Can I do this to my brother bench? After some arguments, Mr. P. Mohanta, learned advocate for the appellant, seeks permission. This we have suggested you only for the reason that otherwise we'll come down very heavily. Not only on you, but on the state on respond number 6, and then it will pave way for the state to appoint somebody else for the balance work. You want that? We will do it. After some arguments, Mr. P. Mohanta, learned advocate for the appellant, seeks permission to withdraw this appeal in order to pursue his claim before the learned single judge learned single judge in so-and-so writ petition, which is pending consideration. Dismissed as withdrawn with the liberty aforesaid. Since the issue concerns the completion of an important infrastructure project, it is expected that the matter shall be decided, that the case shall be decided. I don't think I should be saying this. Everybody is doing his work. You make a mention. Chalo. Yes, next.
Item 11.
Item 11, my lords, I have completed my submissions. They had to answer those 3 queries, and we are here with a written submission. Short.
Give your written submission.
I'll just.
Yes.
Perfect. 3 queries that has been pointed out before this, before your lordship rules. First, in between your lordship has said, what about that, whether there is any history of collapse on L&T? That answer, straight answer, there is no history of collapse. Our undertaking is very clear. And we have given that no condition, is unconditional.
Why should you go to that extent?
No, that's why I'm only giving a reply that your lordship has asked that whether we don't have any history of collapse within the period 3 years. That's the first. Second, which is most important, and your lordship has put a question to me. What about you say about the qualification criteria? Whether it suffers from legal uncertainty and ambiguity. It's like a veil. To that, I'll trouble your lordship because your lordship, we have to show that it is not vague, it is very clear, and there is no ambiguity. I'll show 2 clauses, my lord. Please go through that clause for my satisfaction.
Yes, yes.
Yes. One. Please see 162 of the appeal. It's 161, 2.2.2.4. Kindly see 161. Categories and factors of evaluation of technical capacity. 2.2.2.4. Now please turn to page 162. Please go further down to. There should not be history of collapse of superstructure, substructure of any span of a bridge, flyover, viaduct, metro line work during construction service in last 3 years ending last day of the month previous to the one in which tender is invited. Undertaking in this regard shall be submitted along with the bid. Now, your lordship, when this 1905-2005 was the RFP, and this was the terms and condition qualification criteria. Now, your lordship has to read with this clause, one more clause at page 177. Please read 177. 3.1.6. Test of responsiveness. 3.1.6 at page 177. 3.1.6.1. As a first step towards evaluation of technical bid, the authority shall determine whether each technical bid is responsiveness to the requirement of this RFP. A technical bid shall be considered responsive only if A, B, C, D, please see G. Now, technical bid does not contain any condition or qualification. And this is what. So, my lord, test of responsiveness, when you read this clause 2.2.2.4, 3, that is very clear. Now, a pre-bid meeting was held. Now, in a pre-bid meeting, all the bidders are present, including my clients, my friend's client was also present. Please look into it, how the pre-bid meeting, in what manner at page 211. Please see that pre-bid meeting where a corrigendum was issued on 23/7/2025. All bidders were called for, all the bidders. C211 down below, my lord. 22, my lord. 22. And see that, my lord, a description on the top, query and remarks. And please see 22. Additional experience, history of collapse, deletion of above clause 2.2.24 so and so modification.
That's all right.
I'll tell you what has happened. When all the bidders,
The collapse simpliciter will not disqualify. Just a minute. Let me break it for you.
yes,
Collapse simpliciter will not disqualify a person. A collapse which is attributable to either a design failure or a quality related failure.
absolutely correct.
So if that is not explained, that it was at least an undertaking that it was not a quality failure or it was not a design failure, the disqualification applies.
Now, I will show that. Your lordship, I am grateful that your lordship has put this. Now, to this, my lord, all the bidders are present. What they said we want a deletion of this clause. We also said we want a deletion of the clause. You don't delete it, made 2 years. Now, authority made a period of 3 years, right, my lord? Now, if you see the remarks, for a moment, your lordship has looked to remarks. The clarification has been incorporated in a revised RFT. Collapse of superstructure, substructure pertaining to design failure or quality related failure of permanent structure would be
Correct,
considered.
correct. That
in-
is what I said,
Right.
no?
Now, please look into it, their undertaking. Please look into their undertaking. I just trouble your
Followed,
lordship.
followed,
with
followed.
that
There is no reason given, there is no explanation given.
If there
And in that context, your friend had argued that
Yes.
since the undertaking, the contours of the undertaking were not clarified, therefore it means it could be an open-ended
No
clarification.
format was
I
given or
say
no
once-
guideline. Just add it.
He,
there is no format. My learned friend is saying, there is no format given. To that, I will straight away answer, what more you want? This is what it says 2.2.4 and also test of responsiveness
yes.
and also a corrigendum. You cannot expect from a tender with a more an additional format. This is my query to the answer.
Templates are not always acceptable.
Yes.
Templates are not always advisable.
Will kindly see the undertaking. Please see the undertaking.
Right? We have seen that.
That undertaking is very important, my lord. Page 328. Please see his undertaking. And my learned friend pointed out is not being dealt up by the court also. I'll show it, my lord. Please see page 328. Lordship, what is 328?
Yes.
Now kindly see the third paragraph.
Hmm.
That the qualification requirement under the above referred clause 2.2. So and so, read with the remarks in reply to PB query number so and so. The clarification has been
He starts
incorporated.
questioning it. He has questioned it only. He has not answered that it is not
Kindly
because.
see the collapse. Kindly see the collapse of superstructure so pertains to design failure or quality related failure would be considered in this clause only. It's now what is patently ambiguous, unenforceable, and merit declaration as being void under section 29. So and also violated. So what do you want? What he wants? My answer is that he wants a deletion of this clause because he knows very well he will not be able also to survive if this clause remains. Yes. And my lord, this is what the learned single judge also has said in his particular judgment. I'll show it, my lord, how it was dealt. This said that some authority has to decide about the vagueness, about this ambiguity. My lord, what more you want? This is your lordship knows with great respect. The terms and conditions are not open. It is a author is by the employer. My lord, that particular I will place. I know that's I will trouble with your lordship. After the 3 points which your lordship has placed it, I like to place it last point whether it is open for judicial review. So terms and condition is concerned. How you, my lord, my learned friend is saying now please interpret this clause. Interpret this clause. What we find this clause is there is a vagueness in this clause. My lord, this has been dealt. Now. Now, very interesting. He is referring to the Patna High Court's order of Sultanganj Bridge. Please see his particular last paragraph. Subject to the foregoing, it is disposed in respect of unforeseeable collapse of parts of span on 34 so and so in respect of Sultanganj so and so under instruction of the employer therein and as per order dated 14/9/2023 of the Honorable High Court at Patna under PIL, re-execution of collapse.
As we have followed, this was not what the response should have been.
My lord,
Undertaking this is no undertaking.
it should be a clear
Correct.
undertaking.
Then
No,
next,
what they said,
next, Mr. V.
No, what they said, it is in progress under force
So
measure.
that's why do you have to labor on a point
No,
which
I'm
you
not laboring.
just a minute.
Yes.
Labor on a point which is
Correct,
already settled.
No,
So it doesn't explain, not even a line.
correct.
We have followed
Right,
that. Not
right.
even a line that it was design
Design.
failure or okay, why do you
That's correct.
take another point and
At
answer?
that point, my lord, I have answered. And please, one trouble, I will give you the response, representation which they have filed. Please see the representation at page 260. Please see the
Representation to whom?
that has been discussed to the my lord railway authority. This is 31
Where?
5 2000 at page 260.
Railway authorities where?
Here, to the so and so Northeast Frontier Railway, my lord.
Hmm.
Representation. this
After,
may have
at what
filed.
stage?
Yes,
At what stage?
my lord, at this stage, after the RFP was floated, thereafter they represented this.
No, but before the undertaking, no.
Yes, yes.
That's all finished.
That's,
That's a document which we did
That
need
is
not
where
go
we
into.
sought deletion
Yes.
of the clause.
that they sought for deletion of the clause.
That's not done. That was not acted upon.
Yes.
So over.
Even they sought deletion, just now the learned counsel.
Chip, he did not disturb you.
I didn't disturb. I didn't stand up.
Please take a seat, Mr. Chip.
Also.
Please sit
You
down.
can take
We'll
a seat.
call upon you.
Yes. I said deletion. You also said deletion. I said 2 years, they made it 3 years. Leave that part, my lord. Your lordship is now. Next is about whether the impugn qualification criteria, whether it confers unfettered discretion upon the respondent authority. That's, I think, that's what your lordship was putting.
That was the argument.
Yes, argument. So, my lord, will kindly see. Then I will go back again that the undertaking part. Undertaking part, what he have disclosed in the undertaking part, my lord. What he have disclosed in his undertaking, my lord. So, it is not that they can, it's a mere statement of fact. You have to give a statement of fact. It is mere a statement of fact. There is no question of you are saying that it is it has to be conferred discretion on the respondent authority. It is only a mere statement of fact. What you have to have given statement of fact. You give an unconditional statement of fact which you have not given. So that power you can't say that they have got unfettered discretion upon the respondent authority. That you can't say. That's my lord will be the reply. Now their rationale is a quick page. In the writ petition, which they have not brought before this court, my lord, the NHR in the I don't know whether it is before this court.
Please argue.
Please see this, my lord.
Please argue.
Give a copy to the other side. NHR 30 years. Please see the first writ petition, my lord. This is a railway as written to Mr. Gogoi. With respect to the above mentioned subject mentioned reference, clause number 7 is kept to avoid should the agency in participant bid in so and so is one of the prestigious project of our nation. Intention of the requirement clause is not to disqualify any specified agency. Collapsing incidents have been taking place at many locations recent past in the country. To minimize this type of incident, this clause has been incorporated, which is only self-declaration statement by them. Moreover, so and so. So that's why. Now I will show one annexure, my lord, where the affidavit of the railway man. Please see the affidavit of the railway. Page, my lord, 604 and see at page 606. Paragraph 5 and paragraph 6. Only these two paragraphs now. Paragraph 5. Lordship C. With regard to ensign dependent basis, all queries submitted or raised or discussed in the previous meeting, clarification, modification, bedding, so and so. 6. That with regard to so and so, ensign dependent basis to say the term meaning for collapse has been clarified. In the revised RFP, 5 years history period is reduced 3 years based on the various query. Logic behind this was the management team responsible for such failure of contractor are changing and also the agency improved the working system over the period. So, my lord, the chance was given to all the bidders, my lord. It is that they cannot say it was not given to the bidders, my lord. It was given to him also as well. Para 14, my lord. Para 14. This is, I will not take this point because this is my point that it was given a chance to all the leaders. It is not that a chance was not given. Your blacklisting, I will not raise that point, your lordship.
And these are two
has
different
said
things.
Is that already they have been given the work, there is no question of any black. So I will not place that point, your lordship has already. Now, see the judgment of this court, how it is dealt. While learned friend say it was not dealt by this court. Please see the judgment of the learned single judge. Only 3 paragraphs, my lord. Trouble with 54, which your lordship has read, 54 at page 91.
Yes.
Please see.
Internal page 40.
Para 54, page 91. As a perusal of the above put in undertaking would not reveal the reason why the petitioner referred to clause so and so of the RF as a clarification so given to the patently ambiguous, unenforceable and is required to be declared void. There is no mention undertaken that the bridge which was constructed petition is state of the art over the river where admittedly so and so, and nothing to do with the superstructure, substructure of the bridge, or for that matter, anything to do with design failure or quality refer related failure to the permanent structure. Right now, please see page 92, para 56. Para 56. Question therefore arises to whether clause 2.2. So and so lacks certain legal certainty and device of norms and benchmark. In the opinion of this court, clause so and so does not lack legal certainty or to divide of norms and benchmark. It is also the opinion of the court taking into account the petitioner stand taken the representation submitted on 31/5/2025. It cannot be said petitioner was not able to discern the meaning of the said clause. The clarification which was given on 23/7/2025 further clarifies that for the purpose of the said clause, collapse of superstructure or substructure would be considered if it relates to design failure or quality failure of the permanent structure. Under such circumstances, it is therefore the opinion of this court of this court clause so and so cannot be said to be vague, void, or ambiguous on the ground of lacking legal certainty. The said clause of the RFA cannot also be said lacking norms of benchmark.
Yes.
Now, my lord will kindly see at page 96, kindly see my para 64, my lord.
Page.
Page 96, para 64. Same thing reiterated by the 31/5/2024 representation sought for deletion. No mention, did not understand the scope. That's what they have said. Now, the last one, newspaper, my lord, that's I have given reply. There is a clear undertaking. There is no conditional given by us. Now, please see at page 93, my 58. 58. '93, page 58. Para 58. At the outset,
Yes.
it is observed petitioner cannot challenge the clause 2.2. So and so arbitrary after having submitted the bid. Be it as it may, the court would deal with the same point for determination as contended so and so arbitrary nullified. So now, what was pointed out before the court, before the learned single judge, look here, in the first writ petition, they have challenged the terms and condition of this, of the condition, 2.2.4. And your lordship, this is before the appellate court also now pending. Now, in that case, my lord, they sought for deletion of that clause. You participated in the tender bidding process. You come up before the court, the first writ petition, challenge the terms and conditions of this clause. Now, there was an interim order that was passed by the court saying that yes, pendency will not, they will consider his particular, what he raised. Now, the authority has considered and rejected. They filed an IA before this court, the first writ petition. IA was heard and it was rejected. Then they came up before this court by filing a writ appeal, which is pending, and there was no interim order passed by this court. There was no interim order passed by the court. That was the subject matter of deletion of that clause.
But Mr. Das, Mr. Das,
No,
you
I'm
know,
just pointing out.
he indicated to you, to the parties in the beginning, that we are not getting into this because the judge traversed that.
Yes.
That was the hurdle of locus. Now, if that was traversed, then we
No, but
look at the merits.
the event-
Why get into
Yes,
that it was a day
the
before?
court father has
Just a
omitted
minute.
the other
So
aspect of the matter.
therefore, it can be generalized as that if not before, a day before or day after, it was contemporaneous and that issue loses its significance because the matter was heard. Locus is at the threshold.
Yes.
So why do you get into all that trouble?
No, just I'm pointing out.
Now,
Now, my lord, whether, my lord, I will not trouble the order of the Patna High Court. Your lordship has read the Patna High Court. My learned friend has read some, the second.
That is not
paragraph-
my order, so we have not read it.
No, second paragraph, kindly see. My lord, Patna High Court, he was the agency, my lord, he was the agency who constructed. Design was given to his person.
That has been read against him, no?
Yes, my lord, it is not a force measure. What is submitting that it can be, it is not a force measure, it is a design failure. That's why he has undertaken that I will do it. That's why he is undertaking that I will do that. It's a design failure, my lord. It's not a force measure as he has submitted in the representation, my lord. Now, my lord, one particular judgment, last, my lord, the judgment of the, your lordship has dealt with so many of judgments. I will cite one judgment where whether this court. No, that's a FCON's infrastructure, my lord. 2016, my lord, 16 SCC 818.
Name of the case?
FCON's infrastructure will Nagpur Metro
Alphons.
Rail Corporation.
Alphons, yeah.
That is paragraph, my lord, will kindly see 15. Paragraph 15. Paragraph 15. Paragraph 15.
Yes.
Paragraph 15, we may add that the owner of the employer project having authored the tender document is the best person to understand and appreciate his requirement and interpret his document. Constitutional courts must defer to this understanding, appreciation of tender document unless there is a malafide or perversity in the understanding or appreciation or in the application of terms of the tender condition. It is possible the owner or employer project may give his interpretation of tender document that is not acceptable to the Constitutional Court, but that by itself is not a reason for inferring with the interpretation given. That's what it says. Now,
All right.
question those comes.
Yes, Mr. Chip, now you answer our
One
questions.
point, one or 2 points, my lord.
No, first you answer our questions.
Yes,
One or
my
two
lord.
points, additional points are not required.
Yes, my lord.
Now tell me one thing. Your major argument was that this is open-ended
Yes, my lord.
and without the adjudication of the guilt in the sense that if it is not a design failure or a what is that? The other failure? Design or
Quality failure.
poor quality failure, quality related failure. Now you want that this should have been, introduced in the tender papers in such a way that there was a scope for any adjudicated guilt, whether you were responsible for it or you were not responsible for it. Well, to our understanding, that is something which defies the tender jurisprudence.
Yes.
Now, in cases of fall, if the tendering authority would look for an adjudicated guilt finding, then perhaps it will be very difficult, no? It will take time. It is not adjudicated in a day. It takes time, technical investigations, delayed reports, inchoate reports, acceptance. Now, can a tendering authority wait for that long
Yes, my lord.
for a matter to be decided by some authority, judicial or quasi-judicial authority, with respect to finding of fault? Now, if this were so, the entire project, now any person who has had a fall within within the look back period, say 3 years, 5 years, 7 years. So he would remain eligible till the time he is finally adjudicated guilty, and in that case, he wins the contract. Therefore, this concept itself that there should be an adjudication could not have been part of the tender requirement. Correct? And the law says so. That it's not a judicial trial. This is just one of the indices of assessment, whether it would be safer to consider you for the project. So this adjudication argument doesn't impress us.
Yes, brother.
It can come a long way. It can take a very, very long time. The other question that you raised is for the artificial look back duration.
Yes, brother.
3 years, why not 5 years? Why not 7 years? Why not 10 years? Now, if you have to address anything on that, you please tell us. And I think that's the end
Just
of the
2,
matter.
3 points. I'll just address my lordship with 2, 3 points.
We have our own view about 3 years.
Yes,
The
brother.
purpose is to see the current, reliability of a party.
Yes, brother.
So if it is older, then perhaps it defeats the very concept of right to be forgotten, or for you to improve and generate your own resources, tailor make your system. 3 years, this gap, this look back period or look at period is reasonable. It passes the muster of reasonableness.
Yes, brother. My lords, first and foremost, there is either we can look at the clause in a silo, but if my lordships looks at it holistically, now what would happen if 2 parties are entering into a contract? They are private parties. X party may not like Mr. Chip's face and says like, look, I don't want to enter into a contract. This is not a situation. Here, my lordships, it is a state which is entering into
That's
a
right.
contract.
That's why we are hearing it.
Absolutely. And if the state is entering into a contract, my lordships, the basis or the pivot of my argument is that if that particular condition is vague, now my lordships are saying whether adjudication would happen 6 years down the line, 3 years down the line, we can't wait. Now here there is no case.
Do we stop you here? Where is if the condition is not so wide,
Yes,
it says after your objections, after the objections of others, after the pre-bid meeting, it was decided the RFP condition was changed to the extent that every fall would not be considered against a bidder.
Yes, my lord.
The fall which is attributable to 2 reasons,
Yes, my lord.
poor quality or technical flaw.
Absolutely.
So
But
therefore, it was very specific. Not that every fall would disentitle
I
you.
go down to that. My lords, this is what it looks like at the first blush. But if my lordships looks at the revised tender condition, read with the clarification, there is no change. Apart from that 5 years becoming 3 years, there is no change with regard to the tender condition during construction or during service, number 1. So there is absolutely no change with regard to the tender condition in the revised tender condition. Now, if during construction there is some fall and there is no adjudication of it, there is not even a notice.
We just told you, no?
There is no.
Adjudication would be very difficult. It will take time.
But my lord,
That you were allowed to work is a decision of the employer
Lord,
there.
my
They
lord,
want to be
then I
very
go
sure.
back to my point, when a state is entering into a contract, my lord, it will become too wide, too vague and too ambiguous.
What prevented you from making a disclosure
Yes, ma'am.
that adjudication or no adjudication, my statement
My
is,
lords, just for a moment, look at L&T's.
you have to decide yours.
My lords, look at L&T's undertaking for a moment at page 525. They never say any, till today, the L&T's council has not denied the page 617, which I showed my lordship. They themselves sought deletion of this particular clause.
No, that-
They sought 2 years. Why did they seek 2 years? My lords, they fall, if my lordship express.
Why do we see that?
But my lords, it's L&T which is replying, state is silent.
No.
No, my
Why do
lords,
we see that?
let us look at it this.
Aapki dikhao, whether you had explained.
My lords, okay, let's look at my undertaking again.
Yes, we have seen that just now.
My lords, for me, I was caught, my lords. I had to disclose, I disclosed. There is no adjudication and I put it before my lords. I put it before the tendering authority that this incident has happened. But this clause is vague and ambiguous.
Mr. Chib would be intelligent enough to understand the requirement. Now, if any advocate or any party who has had experience of construction of bridges would know the content and the ambit and the reach of this clause, when the revised RPF talks about the fall to be attributable to two of the reasons.
Yes, sir.
The only requirement of the tendering authority, to our understanding, would be that there should be a denial. Of course, there was a fall, but it was neither because of this or because of that. This statement does not require a lot of, rocket science understanding.
My lords, I pause here for a moment. I am understanding what is falling from my lordship. Now, admittedly, there was a fall by L&T also. Just 1 second, bear with me. My lords may have page 525. 525 for a moment. My lordships has seen at page 617 the fall of their peer. Today the council has not denied it. Vigilance probe adjudicated. Now look at 525. We, Larsen and Turbo Limited, hereby declare that there has been no history of collapse of superstructure so and so during ending last day of the month previous to the one in which the tender is invited. When do they say that fall is not because of design, etc.?
No.
They don't even disclose.
Oh. Within 3 years, if there is no fall, they don't have to say anything.
It is within 3 years.
What?
That page 617 on yesterday, the last argument I showed my lordship, on page 617, there is a fall by them. Now, this is the effect of a vague clause. My lordship looks at 670.
Yes.
And now lordship looks at the impugned order. The peers have been explained by the learned single judge. Huh? Well, let me read this, my lord.
This was of which year?
2025, my lords.
No.
Incident of 2024.
Not at all, sir.
Yes, my lord.
Inquiry likely to be fixed. The date is January 20, 2024.
23
January 20,
incident.
2024.
23 incident and 24 report. Within 3 years. And that is why they wanted 2 years as fallen from the learned council. And that is why they also wanted a deletion. Now, my lordships, I'm not blaming L&T. What I'm trying to say is, this is the effect of a vague clause. And that is why rightly my lordships have said, what is the format? What is the structure? What is the guidelines? And this was before learned single judge. Learned single judge doesn't look at it. No, page number. Now my lordships looks at para 50, page 87. Even the learned single judge in the impugned order.
It only says, page 618, it says further it was found that there was no proper maintenance of the structure, which is just about 4 years old, as the damage was not a development that occurred overnight.
My lords, it is at the end of the day. Now my lordship looks at the impugned order, page 87 for a moment.
This report said.
This fall is not within 3 years.
It's 3 years, my lord.
No.
Let them deny it.
I deny. The report only says.
2023. My lords, page 617, October 21 has last so and so. I'll just show my lordship.
हम परीक्षा नहीं पास किए हैं तो जो पास किया है उसको भी हम पूरा देखें, ऐसा थोड़ी होता है.
My lord,
Litigation does not extend to that, Mr. Chief.
but
You
my
know
lords,
that.
in a tender. Now, just let me make my submission. My lords, for a moment now have page 87 of the impugned order. My lordship, this report is concerning a peer. Now, my lordships have page 87
Of the
impugned order.
so
Page 36.
when you refer to the impugned order, you refer to the paragraph, because we have a
All
different.
right, para 50, my lords. Last 3 lines.
चला गया मेरा वो वाला वाला.
Para 50, my lords. Last 3.
50.
Yes, my lords.
Internal page 35.
My lord, last 2 lines. The key elements of substructure in respect to a bridge include abutments, piers, and foundation. Learned single judge, after holding a separate inquiry, and my lords, learned
Yes.
Now, my lords, my submission is this, I am not blaming Elliot. I'm not saying anything against him.
This is not the occasion for you to do that, no?
Absolutely. All I'm saying is, my lords, I don't want to say it, but it's hamam mein sare hai, my lords. Now the issue is, this is the problem. Why they also wanted a deletion, and they said that the look back period should be 2 years, as rightly fell from the Learned Council, because they were also getting affected. Now, my lords, my submission is why I'm not saying two wrongs make a right. I'm not into that. What I'm saying is, why did such a thing happen? Such a thing happened because the clause is vague, because there is no adjudication, there is no standard. How do you determine whether a fall has happened or not? During the construction, let us say a few bricks fall, half a pier falls, like it has happened in L&T's case.
See,
Well, my lords.
the difficulty, Mr. Chib, is this.
Yes, my lord.
Unless our questions are satisfied, we don't go to the reasoning elsewhere. Now, we have asked you a question.
Yes, my lord.
Our understanding of the requirement, so far as technical competence is concerned, that there should not have been a fall within 3 years
Yes, my lord.
for 2 reasons,
Yes, ma'am.
and an undertaking to that effect. Let's not read it in silos, as you said, that it is not to be seen in silos, but cumulatively all this. The requirement of no fall of a
Yes, ma'am.
span, either during construction or after, within 3 years, whether the construction continues within the 3 years or it is over and during the maintenance part 3 years, that clause becomes operative for 2 reasons.
Yes, my lord.
And third, undertaking that it is not because of these 2 reasons. Where is the difficulty? Where is the scope of further expatiation?
My lords, I'll just explain, my
So
lord.
therefore,
The difficulty.
the difficulty you are facing, definitely, because there are many laws which work against you now.
Yes, my lord.
Now, the tender throwing authority are supposed to be the best judges.
Yes, my lord.
They are supposed to be the best assessors. Assessors, not in that sense
Yes, ma'am.
where assessor is used.
Yes, ma'am.
They are the persons who are best suited with their interest in mind to assess who would be a better
Yes, ma'am.
party, better contractor to be entrusted with that work.
Absolutely.
So in that case, when they just wanted an undertaking and not with a certificate of a judicial or quasi-judicial authority,
Yes,
I
ma'am.
think you were expecting much from a tender assessment evaluation committee.
Yes, ma'am.
When you wanted or you waited or you wanted it to be clarified that
My
there
lord,
has to
for
be an
me-
adjudicated
My
reason
lord,
for fall.
For me, it was like my lordships were saying it was a Hobson's choice. I had to do this. I had to give it. Now, my lords, I'll just to answer my lord's question. My lords, to answer my lord's question, I will look at it from a different perspective. For a moment, bear with me. Admittedly, my lordships, when lordships are judicially reviewing a tender process, what my lordships are reviewing is only the process.
We do review it, one second, with Jagdish Mandal at the back of our.
Absolutely, with Jagdish Mandal, etc., etc.
And not etc. Jagdish Mandal.
There is the plethora, and my lords, that is the only ambit, or that is what my lordships are looking at. Because moment it enters into the realm of decision making, then my lords cannot enter into the minds of the people who make that decision. That is the logic. Like in case of an interim order, when the discretion is challenged, the appellate court always cannot go beyond a particular point because it is entering into the mind of the decision maker. I keep it aside for a moment. Now, my lordship, that process is not under challenge here. I'm repeating my point, my lords. The process is based on specific terms of the RFP or the tender, of course, with the guidelines or light of fundamental rights, etc. I'm not going to go into this. Now, that process gets vitiated if the term on which the process is being applied is vague. And that is this case. This is actually going to be, my lords, I mean, my humble submission, a very important concept that, and it has what has been held in by Justice Kapadia in the Reliance judgment. The process gets vitiated because what you are looking through the lens is of a vague clause. So you are not into the process, you are not into the decision for AFCON judgment, etc. You are looking at a foundation, the substratum or a specified term. That term today is vague, my lordship. Why it is vague? Now I'll answer my question to my lordship. If my lordship says, why didn't you say a fall has happened? I said a fall has happened. But how do I say it is for design failure or not? It would tantamount to self-determination.
Who was stopping you, sir?
My lords, let us say I would have said in an undertaking on an affidavit or oath that this was owing to a design failure by me. Tomorrow, I will have to face the brunt in Bihar, my lordship. They will say, you have admitted before Guwahati, a tendering authority.
What?
You have admitted.
Where
You
is the
have-
question of admitting what was visible to the eyes?
My lords, if it was visible to an eye, that had to be adjudicated. And that is why, my
You're
lordship, the
you're
underlying.
again conflating the same thing.
Oh, my
I
lord.
mean, we are not
I'm
asking,
attempting.
Mr. Chip, we are not asking you to concede on this point. You have made your arguments, we have said.
My lord.
The argument will
My
be
lord,
endless.
My lord, I'm just.
In our estimation.
My written submission covers it, what
Yes.
I'm arguing.
Yes.
This point has been covered, but what I'm saying is that we disclosed whatever was required.
That is your argument.
Number one, and on time, my lord, whatever could be disclosed. Because if, let us say, just for a moment, my lord, let us say, if instead of the word fall or bridge, it was about failing of a child. How do you determine a child has failed? Till you look at the report card. You can't say, no, uske number achhe nahi the, he's not a bright kid.
I think the comparison you should have made was fall of a bridge or sinking of a bridge.
My lords, that's
You're comparing A with Z.
my lords, this is my lords, it is a vague, uncertain, ambiguous term. And that is why all this has happened. L&T, even after a fall, could get through because they just said, now let us say for a moment. If L&T has given an undertaking and they were incorrect, my lord had asked a specific question to the state to answer today. That how did you decide? What went in your mind? What did you look at? Because you never gave a format. You never gave any guidelines. How did you decide? How did the tendering authority decide? Because, my lordship, the underlying substantive clause or the tender condition is so vague. Man, that is what Justice Ravinder Bhatt says in that Atlanta judgment. He says this contract, that NHI contract, that particular paragraph I read out, cannot be used, my lordships, to say, look, because in that particular contract something had happened, till that is adjudicated. It is not a contract between X and Y, two private parties, my lordships. It's a state. State cannot do like this, my lordship. State will have to go on certainty. There cannot, because the moment it is uncertain, that is what Justice Kapadia says in Reliance judgment, there is the level playing field is gone.
Field is disturbed.
My lord, it is a thing to be thought about, and my lord, I'm certain about it that there is something to this aspect that this clause is vague and uncertain. If my lordship sees the Ripley judgment, the Atlanta judgment, and the Reliance judgment, 3 judgments. The rest I leave it to my lordships.
All right.
And it is a case challenging the tender condition, not the process of the decision.
All right.
My learned friend relying on a newspaper article saying that this is what L&T. Kindly see one judgment of the Supreme Court, 2020. One judgment, last one paragraph. 2020, 16 SCC, page 811. See last paragraph, para 6.
Which
Kindly
judgment,
see.
sir, can I have?
Yes, please. Para 6. As noted, para 6. See para 6 now.
Yes.
As noted, the entire basis of making the allegation contained misstatement is an article relied petitioner said to have published in a newspaper. There is no other material record to confirm the truth or otherwise of this statement made in newspaper. In our view, this court will have to very circumspect while accepting such content based only on certain newspaper report. This court is a series of decisions repeatedly held newspaper item without any further proof is of no evidence value. So end of the matter, what is relying? That's what the learned singer is saying.
My lord, we have the Vigilance Committee's report on the fall of their bridge. Criminal action has been initiated on the fall of it. And my lords, if the newspaper report, let them deny it. Let the learned counsel deny it in the open court. Let them deny it.
All right. Arguments heard. We are locked in the arguments of parties inter se. So you
only one page I indicate also.
you are
Page 238 also.
page
Page 238, the judgment of the Honorable High Court. I'll just only that 3 lines I'll read also.
Internal page.
Internal page 238 also.
No, not
Page
internal
238 also.
238.
to 30, last paragraph starts from court line also. The design would now be redone and remodeled with modified technology, and in that event, since the agency has taken up itself the liability so far as the building of the collapse one with no extra cost to the government, we are the opinion that public litigation can be closed. Here also there is admitted fact that design will be redone and remodeled.
You will read it. I have read the other part of the paragraph.
This is the.
No, नहीं, इसको ये तो that's right. It नहीं ना पटना यही है. So you were allowed to work, Mr. Chiv,
Yes, ma'am.
but there is now an adjudication that there was a design failure.
No, my lordship looks at the paragraph above. It is prima facie assumption of the Honorable High Court.
Oh,
Prima facie assumption. My lords,
was that challenged in Supreme Court?
no, why would I challenge it?
So
It's a
therefore,
prima facie-
leave it
my
at
lords,
that,
it will
no?
Close the PIL.
So therefore, it is complete. Anyway, we will look into it.
My
we
lords may
will-
look at my written submissions. as well.
Yes, we'll look
I
at
can
your
say.
written submissions, everything, we will look at it. It's not required now. See, this has been the practice of this court that in tender matters, we are as prompt as promptness could ever be thought of. For the reason that these are infrastructure projects and unnecessarily, so therefore we will say arguments have been heard. Arguments, we have heard the arguments of so-and-so for so-and-so. Post this case for judgment tomorrow. Enough. All right, thank you so much. It was wonderful hearing both of you and Mr. Gogoi also. What? So which is that matter? Just a minute. Mr. Chaudhary is here.
Lordship, I am there on behalf of.
I don't think we can take
Yes,
up
Lordship.
any other matter. We have a reference.
Tomorrow or day after tomorrow, Lordship.
And reference cannot go without me. So we have to leave this.
Exactly, Lordship.
All matters, which is urgent, ask from them. And where is that date of birth, Mr. Silo? Is he here?
My lords, I'm here.
He's
My
on
lord.
VC.
Am I audible, my lords?
You are as usual audible, but not visible.
I am unable to click on this. It's unresponsive, my lords. My video
Your
feed is
video is
unresponsive,
unresponsive. So what we do is that we give you a date.
my lords.
Take the date from the court master.
My lords.
I don't think you have retired already, so there is no great urgency in hearing you tomorrow.
My lords.
Right? So
My lords may hear me after 3 weeks.
After 3 weeks, yes. Mr. Chaudhary's matter, when do we hear it? What is that matter? That principal's appointment.
Yes, sir.
Yes.
24, Lordship, item number.
So that comes on today's Tuesday, no? It comes on Thursday.
Thursday, Lordship.
Thursday.
Much
All right.
Item 27, urgent because it is a matter relating to retirement benefits.
Item number 27.
Item 27. 30th April. 30th April. 30th April.
I think it's a pay. The same fitment table.
Yes, that is fitment table matter.
So where is the urgency there? Where is the urgency
One
there?
of the repetitions
I mean,
of-
every matter is urgent, but don't make a statement which is not supported by records. We are aware of everything that comes before us. Don't make any casual statement, otherwise, this court remembers the faces of the advocates. Make a mention that we would like it to be heard. We will accommodate you as far as possible, but please, this is a, I wouldn't say warning, it's a caution that if a court feels that wrong statement has been made even casually, then it becomes very difficult for us to rely.
I apologize.
It's not that. It's a different matter. Fitment table.
Yes, fitment table.
Correct.
Yes.
So the pointers, the multipliers of 3.36 and all that, is that the case? Where is the urgency for hearing tomorrow? इनका भी date दे दीजिए कभी. Take a date.
My lords, I'm
immediate
sorry
date. We'll
to
give you
interrupt.
as early hearing as possible.
Much obliged.
But
Much
don't